In brief conclusion, Mr. President, I would advise the House that I am going to move an instruction to the committee, to Committee of the Whole to divide the bill. Obviously, most of the concerns that have been raised are to do with those changes to the Local Government Bill, and that will give the honourable members an opportunity to make the amendments they feel needs making, including, if necessary, making some amendments consistent with the concerns they've raised, without impeding the orderly debate and passage of what I believe is urgent changes to electoral funding legislation. And with those remarks, I commend the bill to the House.
The question is that this bill be read. Sorry. The question is that this bill be read a second time. All those in favour, please say aye. Aye. Those the contrary, no. I think the ayes have it. The ayes have it.
Electoral Legislation Amendment, Local Government Elections Bill 2021, second reading.
Now, who's seeking the call? I think
I am, actually.
Well, I am too, but I'm okay for Don.
What did you just do then? Did you just put the second reading?
Yep.
Yeah.
So now, after the motion the Minister says, I move, according to sessional order, that it be an instruction to the Committee of the Whole that A, the committee have power to divide the Electoral Legislation Amendment Local Government Elections Bill 2021 into two bills, so as to incorporate in a separate bill the amendments relating to the Local Government Act 1993, and B, that the committee report the bills separately.
Mr. President.
Mr. Shoebridge.
President.
Oh, sorry, just before you do, Minister, you don't want to say anything with regards to it?
Thank you, Mr. Deputy President. I will refer to the remarks I made just at the end of my speech in reply, and ask honourable members to take them into consideration.
Right. Sorry, David. Mr. Shoebridge.
Mr. Deputy President, I move, according to sessional order, that it be an instruction to the Committee of the Whole that they have the power to consider an amendment to the Electoral Legislation Amendment Local Government Elections Bill.
No, David, before you do that, we've got one motion before the House which I think has to be put, and then yours will be put separately.
All right. We can't have them both on the table and then vote on them seriatim.
Well, you can just speak on mine and advise that you'll be moving something else.
Yeah, I think that's probably the way, yeah.
The Greens don't support the splitting of the bill. We see genuine merit in having the two bills dealt with together as a package to deal with the upcoming local council elections. There is a concern that if the bills are split, because the government is so keen on being able to rope in their rogue local council candidates who and bring them into the fold and actually run the ruler over their accounts, that they may proceed only with that in the other place and drop the changes, some of which we think are important in relation to COVID, safety protocols and other matters in the amendments to the Local Government Act. Obviously, we have amendments that we're moving to the Local Government Act in committee that we think are as critical, in fact far more critical to the integrity of the council elections, being the prohibition on property developers running for council. We think that's a far more important integrity measure of a far higher value to the community than the very modest changes the government is proposing in its reforms to the Electoral Funding Act. We think that there is a strong political reason to keep the two together, not have them split, because the danger is that they'll be split if they're split here, when they get to the other place will vote up the changes, will vote through the changes to the Electoral Funding Act that the government wants, but will leave orphaned, unaddressed, the far more important integrity measures, which are actually prohibiting property developers from standing for council. If you ask the people of New South Wales, the ordinary mum and dad in the street, what do you think is more important for the integrity of local councils? Getting property developers off councils, or some abstruse change to the accounting rules for the election. I reckon they would say almost to a person, except for, of course, some property developers that want to run on Liberal ticket, except for the And I note the Honourable Wes Fang thinks the people of New South Wales don't care about having property developers run for council. That may be his position. I think he should get out more, and I think he should go and talk to people on the street, because people are very concerned about property developers corrupting local councils. We know there's an inherent conflict of interest in that. So, Mr Deputy President, for those reasons, we don't support the split of the bills.
Oh, sorry, do you want to say
Yeah. The Honourable John Graham.
Thank you, Deputy President. I might just indicate the opposition's view at this point. I spoke in my second reading contribution about the principles we'd apply to this bill. We do share the concerns of Mr David Shoebridge. In fact, as I've said, our members have moved in this House bills to the same effect as the amendment he's just flagged. So we do share those concerns. That is one of the principles here we'll assert. The second is that where possible, this electoral legislation should not be the subject of partisan backwards and forwards, and I thought the Minister in his contribution well articulated that principle, including some of the discussion about how the Joint Standing Committee has worked at its best. So those are the two principles we're seeking to balance. I don't agree. I've agreed with a lot of what the Honourable Wes Fang has said this week, I have to say, a lot of it. I don't agree with the suggestion, though, that this isn't something that people do care about out in the public. These are very important issues. That's why we actually seek to take a principled and balanced approach on this. As a result, we're happy to support the government attempting to split these bills and let them carry on down into the other place if this is successful. We will be arguing the case for both these measures. We'll be arguing very strongly for the provisions that the government says are integrity measures. We'll be arguing equally strongly, in fact, probably more strongly, for the argument about property developments. I accept. We've been doing it for 2 decades. I accept that is a more important measure, and I do think it will be a problem for the government to put the case that the Minister's put today about the importance of these COVID-safe measures, and for the government to take the path which Mr David Shoebridge has said he's concerned about. That would leave the Electoral Commission in a very difficult position, and we will argue the case for those COVID-safe measures and any anti-developer measures that are put forward and successfully amended here into the bill. They should both be dealt with seriously in the other place.
Just in reply, and very briefly, Mr Deputy President, I hear what both honourable members say, but I would make one important point, which is the amendment that is proposed is effectively relitigating a debate the House has had and that the other House has had. And at this stage, the position hasn't changed at this stage. But nevertheless, to facilitate the orderly consideration of all the provisions in the legislation, the government strongly suggests to the House that the best way to proceed at this point is to split the two bills, and I thank the Deputy Leader of the Opposition for his comments.
Right, now I'm going to put this question. I think the form of the instruction has been distributed about the chamber, so I won't read it in its entirety. The question is the motion of the Minister. All those in favour, please say aye. Aye. Those to the contrary, no. No. I think the ayes have it. The ayes have it. Right. Oh, there he's there. So just before we do that, Mr Shoebridge.
Oh, yes.
I think I'm getting the eye from below. Mr Shoebridge has a motion that he wants to move as well.
Yes, Mr Deputy President. I move, according to sessional order, that it be an instruction to the Committee of the Whole that they have power to consider an amendment to the Electoral Legislation Amendment Local Government Elections Bill 2021 relating to prohibiting property developers from civic office. I'll speak briefly on it.
Yeah.
I think this is probably not necessary, given the long title. It's the long title almost certainly, as currently drafted, clearly encompasses the amendment that we're intending to move in committee. We're moving this for the avoidance of doubt, so there can be no argument and no surprise in committee when we get there. Often the person chairing the committee can be a little unpredictable in their rulings, and we just want to ensure that we sort of lock it in advance so that we don't get caught by that sort of unpredictability of the chair.
Well, he's off the Christmas card list. Is anyone else seeking the call?
One, the support of the House.
Well, I think in the circumstances, before I put the question, I might leave the chair and give it to the President so that I can be ready for the next part. Yes, the unpredictable part.
Were there any other speakers in relation to the motion of the honourable member?
Look, I won't detain the House for what's been a long debate. At this stage, the government will oppose the instruction, consistent with the position that we've had on this issue in the past. But I see what the will of the House is, and I accept that we'll be debating it shortly.
And Mr. President, I'll simply indicate that the opposition will be supporting the instruction.
Mr. David Shoebridge in reply? Okay. If there's no further speakers, the question is the motion. The question is the motion of the member. All those in favour say aye. Aye. Against say no. Aye. I think the noes have it. The ayes have it. Division required. Ring the bells. Withdraws the division for Mr. Shoebridge. Yeah, I did.
Mr. President, I seek the leave of the House to request that the vote on the Honourable David Shoebridge's motion be put to the House again, and that the division that has been called no longer proceed.
Okay. Is leave granted?
Yes.
Leave is granted, so be it. Division. I now put again the motion. The question is the motion of Mr. David Shoebridge. All those in favour say aye. Aye. Against say no. I think the ayes have it. The ayes have it.
Okay, thank you. Something I said? No.
Okay. Your mere presence made
Minister? Minister?
Yeah, no, good.
Committee?
I move, according to the instructions of the House, that the bill be divided into two bills. Sorry, no?
We're still here.
Oh, I do apologise. Mr. President, I move that the House resolve itself into a committee of the whole to consider the bill in detail.
The question is that I do now leave the chair and the House resolve itself in a committee of the whole for consideration of the bill in detail. All those in favour say aye. Aye. Against say no. I think the ayes have it. The ayes have it.
Thank you. Thank you. Right.
Mr. Deputy President.
Shoebridge is going to move an amendment to the government. Yeah.
Right. Right. So what is this thing called now? All right. All right. Good. The Electoral Legislation Amendment Local Government Elections Bill 2021 is leave granted to take the bill as a whole. There being no objection, I'll proceed accordingly. The Minister is seeking the...
I move, according to the instructions of the House, that the bill be divided into two bills and that Schedule 2 on pages 5 and 6 be incorporated in a separate bill, the Local Government Amendment Elections Bill 2021, with the following long title and provisions. A bill for an act to amend the Local Government Act 1993 to provide for matters in relation to the postponement of local government elections and for related purposes. I don't have to read the rest, do I?
I hope not. Minister, do you want to speak to that at this stage? Or?
Mr. President, I think now that essentially the reasons for this have been canvassed, firstly in my speech in reply and in a short debate that we had before we came into committee, I will rely on the remarks I previously made and hope for the support of the House for them.
Mr. Graham.
I will similarly refer to my previous comments, but just make it clear for the House that we'll be supporting this instruction as moved.
Mr. Shoebridge.
No, this is not that.
Mr. Chair, I won't repeat what I said in the debate,
Yep.
but for those reasons we oppose the splitting of the bill. But I also, I'll also move an amendment to the amendment moved by the Leader of the Government. With the House, I seek leave of the House to move amendments numbers 1 and 2 on sheet 2021-076 capital A, which includes the handwritten amendments that create the new amendment number 2 and the amended preamble to number 1. And if leave is granted,
At this point,
I'll move it and then I'll...
ask.
Well,
Is that necessary to be done at this point, Susan? Right. Yeah, understand. Just wanted to make sure I could give leave.
So I seek leave to move the two amendments together.
yeah, is leave granted to move the amendments together?
Aye.
Aye.
There is no objection.
I move those amendments, and just for clarity, because some of it's handwritten,
Yeah.
it's better handwriting than mine, I can add, but so it's legible. Amendment number 1 will read, the preamble will read, that the amendment of Mr Harwin be amended by inserting after the words Schedule 1 Amendment of Local Government Act 1993, the words that are found in the proposed new clause 1A. Well, 1A, section 275, who is disqualified from holding civic office, insert at the end of section 275(1), subsection 1, subsection H, or Roman I, if the person is a property developer. Clause 1B of section 275, subsection 8, insert after section 275, subsection 7 before the note. If on the commencement of this subsection a property developer holds a civic office, the person is not disqualified from holding the civic office because of subsection 1I for the balance of the person's term of office or for the period of 6 months, whichever is a shorter period. And 1C, section 275(9), insert at the end of section 275 after the note. Subsection 9, in this section, property developer has the same meaning as in the Electoral Funding Act 2018, Part 3, Division 7. And then amendment number 2 will read that the long title be amended by inserting, open quotes, prohibiting property developers from being councillors, end of inverted commas, before, open inverted commas, and for related purposes. So they're the amendments I move. Mr Deputy President, for more than 2 decades, the Greens have been calling for property developers to not only cease making contributions to local, state and federal elections, but also for property developer influence to be removed from local council. I credit the work of one of my colleagues, a former member of this place, Ms Lee Rhiannon, for the work she did with her very clear articulation of the need to get rid of corrupting donations from elections, local, state and federal. The website that Lee Rhiannon developed, which was the authoritative place to go to look, to find the kind of corrupting developments that really did undermine democracy in New South Wales, local and state. Democracy for sale was one of, I think, the most important political reform moves that we've seen in New South Wales. And thankfully, due to that work, due to the work of Ms Sylvia Hale, and I particularly note the way she tracked the donations that went to the Labor Party in relation to the proposed development at the Killalea State Recreation Park, and she tracked the developments and then the planning gifts that were given by the then Minister for Planning at the time, and it really put onto the public attention. It really brought to the public attention just how corrupting property developer donations were. I also credit the work of my former colleague, Dr. John Kay, and the work he did not just on property developer donations, but also on gambling, tobacco, and other interests. This has been long-standing reform for the Greens, but it's incomplete. And at the moment, we still have the situation where property developers, yes, they're prohibited from donating to local council campaigns, and that's due to that long history of work. But they can avoid that whole constraint by just getting themselves elected onto local council. I mean, I shared the fact that we were doing this on social media earlier tonight, and a whole bunch of people came back and responded, but we thought property developers were already banned from being on local councils. I mean, most people in New South Wales just assume we've got on and fixed this. But unfortunately, the Liberal Party seems committed to ensuring that property developers can actually get themselves elected onto councils. Now, I don't know if there's an internal rule within the Liberal Party to prevent property developers being endorsed candidates. Probably not. I mean, it might knock out half the candidates, the Liberal candidates in northwest Sydney, if they did that. But let alone Parramatta. But when you talk to people, members of the public, you talk to people in the street about this, they know that there's an inherent conflict between property developers, having property developers on local council. They know that property developers should not be on local councils, and it's not, property developers make most of their, the largest conflict of interest for property developers on local council isn't even individual development applications. Although, outside of Sydney, Newcastle and Wollongong, property developers in the rest of the state can actually decide development applications if they're councillors. They'll actually decide the developer applications, whether it's a block of flats in Tamworth or Dubbo, or down the south coast, up on the north coast. Property developers, under the Liberals' proposed model for New South Wales, property developers can be deciding development applications on council. But the real money to be made in Sydney and Newcastle and Wollongong for property developers on council isn't actually even deciding DAs or having a role in deciding DAs. The really big money is getting advance notice of proposed rezonings. Because if you've got 6 months advance notice of proposed rezonings and you're a property developer and ethics aren't a problem for you, well then you can purchase that land in advance, or you can get a mate or a friend or have a quid pro quo with a property developer on another council, and you can exchange the information, you can purchase the land at its current zoning, and then 6 months later when it's rezoned to upsize the development potential, millions and millions and millions of dollars can be made by property developers on council. That's where the big money's made. That's where the tens and 20s of million dollars are made by property developers. It's in the rezoning. And having property developers on council means that they can have 6 or 12 months advance notice of proposed rezoning, rezonings in their local council area. And they can move ahead of the market and reap windfall benefits from those prior owners. And that's, if for no other reason, the Liberal Party should be joining with us and saying, of course property developers shouldn't be on local councils. Of course they shouldn't be on local councils. I mean, the conflict of interest is so obvious. Yet the hill the Liberal Party is willing to die on, 9 weeks out from the start of local council elections is they are going to die in a ditch and say they are 100% ideologically committed to putting property developers on council with a big Liberal endorsement sticker on their back. And why would they do that? What is it so precious about property developers that they're willing to put their interests ahead of the public of New South Wales? Why are they so committed to getting property developers elected onto council? The Greens not only endorse this amendment and support this amendment, but we cannot comprehend why anyone who is interested in removing corruption risks from local government wouldn't join into this and celebrate it. So I wait to see what possible arguments the Liberal Party can put to oppose this amendment.
The Honourable Mark Latham.
One Nation opposes the amendment on the principle that people shouldn't be rubbed out of our democratic system other than the obvious of those who are in jail. I mean, you can run through a whole long list of people who technically might not be suitable to local government service and say we're here to rub them out, but in a democracy, people have that basic fundamental freedom and right to run for elected office. And that is the most sacred of all democratic principles. And most likely under the Australian Constitution and implied rights, this would be rubbed out in the High Court. Because the idea that certain classes of people aren't eligible runs against the implied right of the freedom of a democratic system to be elected to serve your community. And you could make an argument, for instance, Mr Deputy President, that people who sneak up in the dark of night to deface municipal statues are not suitable and shouldn't run for local government because they can't be trusted with municipal property. You can make an argument that people who've been convicted rapists and pedophiles and murderers and serve their time and go into the community as free citizens, they're not suited to run for elected office of any form. You could make the argument that political parties that are committed to creating mass unemployment in coal-based regions and causing untold human hardship are not suited to run for any form of elected office, local, state or federal. So we could stand here all night rubbing people out, but the fundamental truth is, and I reach back to my own experience in local government, where, sure, there are property developers, there are people trying to make a quick dollar, and the best way of dealing with them is the declaration of pecuniary interest. And I reject the idea that somehow, if you're on the council, you've got an idea of where the zoning maps are going. They're determined by the state government. They're publicly displayed. And I suppose it also cuts both ways. I can remember back on Liverpool Council where we had the majority, there were a couple of Liberal real estate agents on the council. And I must confess, all these years later, we did go out of our way to make their development interests so much harder at the council. And I dare say by running for council, they lost money. We gave them such a hard time, you know, but I was truthfully and still am today against urban sprawl, against overdevelopment. I didn't like the idea of real estate agents making a quick dollar and we stopped them doing that. So they had to declare pecuniary interest, and in many respects those who had property interests on a council were known, obviously. Everyone was watching them like a hawk. There were moves even within the factional machinations of the Labor Party in Liverpool at that time to rub out a Labor councillor who had property interests. And I still think to this day that might have even been internal. I know John Graham's shocked that the Labor Party could be like that back in the day, and it's cleaned up its act. There's no internal machinations in 2021. But back in the day there used to be. So these property owners on a council are very exposed. Everyone knows their interests, everyone's sweating on what sort of pecuniary interest they declare. But the basic rule is that if you've got the property interest, you can't vote on it. You can't vote on it. What's the green point? You're up at...
The Liberal Mayor of Strathfield forgot to tell people...
Okay. Well, one of your staffers was up defacing municipal property late at night, and you've got no problem with that. Are you moving a motion to say that your staff who deface municipal property are suitable or unsuitable as municipal candidates? So, order debate, Deputy President.
No, order. Please sit down. Ooh. Sheriff. Look, it's 9:30. You're not helping Mr Shoebridge, nor are you, Ms Boyd. And
She made me.
Put him on a call.
Kick her out.
Pick an example. Kick her out.
if you can complete the contribution without encouraging those two, that would be helpful.
I'm just speaking in favour of the ratepayers of Sydney who don't want their municipal property attacked by sewer rats coming out late at night with spray paint cans to deface municipal property. I don't think people like that should run for municipal office. If you can't respect municipal property, how can you be a municipal candidate? So, you know, these are ridiculous arguments that essentially Deputy President...
Point of order.
Well, punching down's the only way you can ever find you, pal. Way down in the gutter with your staff.
Flaming rats, terrible.
I love the green interjections, you know, because they always argue against themselves. I mean, it's unlimited who we can ban from municipal office. And the whole point is about anti-corruption. The best way, of course, is have systems of pecuniary interest declaration in local government, have it all transparent, have these people known, they certainly are. Apparently there's a problem with some Liberal bloke at Strathfield Council. Well, he's been caught out in the system, apparently, and there'll be repercussions. And then the people vote on him in September if he's allowed to run again. But if you've done the wrong thing and you've committed illegalities and you reach these convictions, then you're not allowed to run automatically under the law as it stands, and that's right and proper. But for the Greens to decide that property developers are like some kind of disease and they have the right to rub them out, I think is just plain wrong, because we could all stand here all night rubbing certain categories of people out when under our democracy the basic right is the freedom to run and be judged by your peers in the community. And I've got to say, yes, there have been some dreadful people in local government. Some are property developers, some aren't. There's also been some property developers who serve with some distinction, and property developers who put a hell of a lot of money back into the community. Some of them still get a bad press in the media. But, I mean, you can't say that because someone invests in property and development, they're automatically a dishonest person. I mean, the illogical position of the Greens is to say that because you've got certain business interests, you're automatically a dishonest person who can't be trusted. Well, I don't think we've got the right to say that. We haven't got that knowledge about every single aspirant for elected office, and it's not such a bad thing that people invest, create jobs and economic opportunity in our communities. That's not a bad thing. I know in the world of the Greens, any form of private business activity is automatically bad, but that's certainly not a community standard and value that's shared across New South Wales. Now, I think we need to be realistic about this. It's probably going to be knocked out in the High Court if the chamber was so foolish as to carry this position, and the Leader of the Government agrees with my bush lawyer assessment, and you're nodding as well. So I know I'm on strong ground here, Deputy President. Very, very strong ground. I've got the bush lawyers and the traffic lawyers on my side. So we're marching down to Canberra to the High Court, confident that we've got Shoebridge QC covered. We've got him covered on the constitutional legality of this. We've got him covered on the basic democratic principle and the absurdity of trying to rub people out when we're not in that capacity. There's no one who ever runs for elected office without sin, without fault. And all you can do is put in place your logical anti-corruption measures, declaration of pecuniary interest, transparency. We've got a corruption commission in New South Wales. You know, it's an imperfect business, public service. Not everyone does it properly. And for those who do it improperly, we find out and we deal with them, and we don't need this resolution from the Greens.
Mr. President, look, I don't want to relitigate the whole debate, which actually was held in this chamber not so long ago. I will say, of course, the government has made several, has legislated several integrity measures to improve standards for councillors, including, of course, the changes we made in relation to Sydney Metropolitan Council, Central Coast and Wollongong councils deciding development applications. These decisions are now made by independent panels. We also brought in a new model code of conduct for local governments in New South Wales, which was implemented in 2018 to strengthen the ethical, accountable and transparent operation of local government across the state as well. So both of those have been important measures. So to say that the government has not done anything in this area would be a mistake. I do, however, want to just focus on one particular aspect why we think it is foolhardy to go down this path, and it is exactly the point that the Honourable Mark Latham just made. A number of members have said, including the Honourable John Graham, including the Honourable David Shoebridge, that this is a far more significant, in their words, integrity measure than what we have proposed for the electoral legislation. And without making any observations on the merit of their comments, at face value, that's in fact true. It would be a far more significant change. What we brought in is a relatively minor change. What the honourable members are suggesting is a major change, and in my view, for it to go ahead, firstly, it should go through the Joint Standing Committee on Electoral Matters as well, simply because it is a major change, and to be consistent with the remarks that members were making in terms of partisanship. In fact, JSCEM should have considered this before the House, on either this occasion or the previous occasion, considered those bills. I won't draw the obvious conclusion on, therefore, how one should regard the previous bill or this amendment, because it's getting late and we need to get on with things. But I would make the very practical point that our election funding legislation has been on the High Court, in the High Court on several occasions in the last few years. And the most recent one was in terms of changes we made to the expenditure limit for third-party actors in elections. That was an amendment that the government put in without it having gone to without it having been looked at by the JSCEM, and without some of the tests that have been put down in previous High Court cases being met. And I would submit, as the Honourable Mark Latham said, that this provision, which is a constraint on a capacity for someone to contest an election, equally is in jeopardy from the High Court. Should it be passed? There has not been the reasoning that's been gone through in terms of what judgments have previously said, and I know that will be contended, but there is a school of thought who has that view. But in any case, I go back to the previous point I made, which is this is a very significant point that should have gone to the JSCEM first, and but I won't relitigate the rest of the argument that I previously made, other than the few brief points I made as to why the government won't be supporting it.
No, Mr Graham. I think it's only fair that the person leading on the bill gets the first punt. It's fair
call.
Yeah.
Thank you, Deputy President.
Mr Graham.
I thank the members for their comments. I want to indicate firstly that the opposition will be supporting this amendment from Mr David Shoebridge. I'm glad that the Honourable Walter Court is in the chamber for this debate. He was referred to earlier in the second reading debate, and he may recognise some of the work that's here in the amendment, because he introduced into this place a bill which had a very similar effect. And certainly he, the Honourable Adam Searle, the Honourable Peter Primrose, all spoke strongly in support of that measure at one point or another. And they did so because this is the policy of the opposition. We believe this measure should be adopted by the government, and we've taken steps to bring that to a head. Mr David Shoebridge ran through the history in his view of some of these changes that have occurred in the way that property developers are dealt with by the donations or the electoral system. And I certainly don't seek to diminish any of what he's put on the record, but I will indicate that, of course, those donations changes that went through that took developers out of the system were not just supported by those members he named, but by a majority of this House. A significant number of other members of this chamber and in the other place who drove those changes through the law in New South Wales to make sure that developers couldn't donate in New South Wales. And when that happened, I do want to particularly mention the Honourable Peter Primrose, because he has been a long-term campaigner for those particular measures, and I have seen that over decades myself. When those changes came through, the government was told that it couldn't introduce those changes, that it wouldn't be possible to define those developers in that way, to take them out of the donation system. The government was told and given advice at times that there would be a High Court exposure, that this wouldn't survive some sort of court case. That hasn't proven to be the case now a significant number of years down the track. So it's in that tradition, for similar reasons, that we support the amendment that's being moved by Mr David Shoebridge today. That's why the opposition has brought this measure before the House previously. Now, I accept the... we don't do so lightly. People should be able to run for public office wherever possible, but it's not an absolute right. It is in some ways less of a right than freedom of speech, the freedom to run for political office. And we do think, given the history of Sydney, given the history of trouble that's happened in New South Wales on these issues, particularly in relation to development, particularly in relation to local government, particularly in relation to developers, that there is a special case here. But it isn't taken lightly, and I think that's important. It shouldn't be the case that this is about taking classes of people and saying you cannot serve in public office. But we do have a particular problem in New South Wales. That's why the Independent Commission Against Corruption was required. It's why it's been so important in modern times to dealing with some issues that are hard to spot in government, in political parties. Corruption is something that has to be tracked down and rooted out. It isn't always obvious at the time. So for those reasons, we say this is a special case. I encourage the government to adopt these measures. If the government won't adopt them tonight, and that's the view from the Leader of the government tonight, I encourage the government to reconsider its view in the other place. If these measures are passed, I call on the government to consider supporting these measures in the lower house if these amendments are successful. There have been changes driven by the government. They're not enough in the view of the opposition. They don't go far enough. They don't tackle these measures to the extent that the community expects. Should this matter have gone to the Joint Standing Committee on Electoral Matters? Well, we would certainly welcome its consideration there, but I do want to place on the record this is no sneak attack. This issue's been coming for some... this issue's been coming for some time. So we'd welcome consideration there, but we're not going to hold up consideration of this bill so that we have some inquiry 73 days out from a local government election. We would encourage the government to change its view in the Legislative Assembly on this measure. Don't put... I just want to refer back to those comments from Liberal ministers in the media. Don't put Dracula in charge of the blood bank on this one. We support the view of Minister Keane. This should be about the community interest, not what someone's getting out of some development interest. We will be raising these issues on the campaign trail. We will be looking at the funding of candidates that are running in these elections in 73 days' time, and looking for these sorts of conflicts of interest, which are not always declared. So there will be ongoing scrutiny of this over the next period. For all those reasons, the government should really consider its view about the position it takes on this bill if it is successful passing this chamber tonight.
Mr. With the indulgence of the Honourable Wolf...
well, it's my call. It's not up to him.
I would seek the call just to
I'm giving you the
add
call.
something that I left out before. Thank you. Mr. President, I first of all won't go through the many remarks that the Honourable John Graham made, except for one, which was encouraging the government to consider the position should this motion succeed. I certainly will be raising that issue with my colleagues tomorrow. And one other thing that I should have said is this. The definition of the property developer, which in its current form actually was put in place as the result of a government bill, was put in for the purposes of ensuring that there was a workable definition of what a property developer was, which is very, very casts the net very widely, if I might put it that way, to try and respect the spirit of what has not been challenged for some time in this House, which is that property developers should not be able to donate. Now, there's a lot of... the term property developer is very broad. It can go from Lend-Lease to someone who puts in, you know, a family who might put in... How many did the Honourable Member say? 2 DAs in how long? 1 year. In 1 year, which is not a lot, right? But it's very broad, right? And in terms of a DA can be to deal with a very small matter. For example, if a person owns an investment property, right? Let's say a beach house, and you put in 2 DAs to renovate the beach house, in 1 year, you're defined as a property developer, right?
Carrying on a business.
Well, with great respect, if the beach house is for holiday rental, it is a business. So it is a very, very broad definition.
Order. Mr Shoebridge.
I'll deal with it.
Yeah, deal with it.
That's right. It's a very, very broad definition. And to then say all of those people should not be able to run for council is, with respect, I think, grossly unfair. The government did the right thing in casting the net widely in terms of the definition as it related to donations, but to use what we did in a bipartisan fashion to respect the wishes of the House, to then exclude someone from their right to run for council would, in my submission, be manifestly unjust. Now, I accept, and indeed, as the Honourable John Graham has adverted to, there are, just like there are on any number of issues in public policy, divergence of views within political parties. But I can tell you that the Liberal Party's position is that it is completely wrong to use the definition of a property developer, which is very broad, for good reason, to exclude people from running for public office. If we're going to do it, and that's one of the reasons I suggested the JSCM look at it, it should be a far narrower, well, I'm not going to say far narrower, a narrower definition, because in my view, a large number of people who aren't the sort of people that the Honourable David Shoebridge or the Honourable John Graham or other members will refer to in this debate, it catches them, and that's wrong.
No, I'm going to do Mr Buttigieg because I set him down on his tail before, so I think I should give him the first job. Yep.
Thank you, Deputy President. I do want to make a brief contribution and place on the record my support, and I want to thank my colleague, Mr David Shoebridge, for bringing this very important amendment. And as has been pointed out and alluded to on a number of occasions tonight, it is the crux of the matter, not trying to downplay or discount the importance of the government's bill, but let's face it, that bill was largely designed to deal with what I think, if I think is correct, the matter of the Strathfield Mayor. And what it basically says is that we don't trust our candidates to make appropriate declarations.
Order. Look, we've got an amendment before the House, which is with regards to property developers. So this isn't a second reading speech. So I invite you to address Mr Shoebridge's amendment rather than in a broader sense.
My point was in relation to the relative...
Well, I've made that observation.
I'd also make a point of order. Effectively what the Honourable Member is now doing is making an imputation about me, and why, even though he didn't name me, and why I brought this bill into this chamber, and he's absolutely wrong.
Right. Well, you've heard that. I'm encouraging you to come to the point of the issue, and the minister has made a fair point as well. So
Thank you,
let's
Deputy
just get
President.
to the point.
The reason why this Greens amendment is so important is that the current system is patently not working. This idea that you can have code of conducts and declarations and, you know, trust me, I've declared it, therefore there's no problem. The idea that you declare something doesn't necessarily remove your ability to manipulate the system. You can declare what you want on a form, you can recuse yourself from meetings, but you can still have access to information and decision-making which other people don't have, and by virtue of the conflict which is still inherent, favour yourself. And that's what's going on here. And if we remember that case of the Mayor of Strathfield, you had a fellow here who was fined in 2013 $43,000 for a development without a consent, then was subsequently elected to Strathfield Council, didn't fill out the form properly, and presided as mayor over LEPs on planning decisions that had significant effect on the area he was representing, and then was subsequently found to be a member of several companies, 13 entities I think it was, which were involved in property development. Now, if the Liberal Party was serious about this, they would have changed their own rules, and I'm not for a moment pretending that this doesn't happen across party lines. We've had problems in our show as well, as you well know, as everyone well knows. But back in about 2015, or around about then, I think, we changed our rules to ban property developers becoming candidates in local government elections. As far as I understand, the government, the Liberal Party, have not done that. The Coalition have not done that. And I think it's high time that the public of New South Wales deserve a system where they know that there is no ambiguity over this stuff. There's no fudging it. There's no filling out of forms and then pretending it's all okay and then subsequently still benefiting it. And what the amendment does is put up front that a clear conflict which occurs in these situations, has been pointed out in the debate before, you're not allowed to become a candidate. It's a very simple proposition. And what it does then is put a proactive system in place so you foreclose all these things up front rather than relying on a reactive approach whereby someone's made a declaration and then we're relying on someone to realise what the conflict is and expose it publicly. So in the case of the Strathfield Mayor, for example, we had a situation where the Office of Local Government was notified back in 2019 of the fact that this fellow was involved in development and was presiding as mayor over LEPs. And nothing was done. The investigation then subsequently took 2 years, was referred to NCAT, and then finally, my most recent understanding is that the mayor is not going to run again in the council elections. And that's where we've ended up. In the meantime, the public's lost faith and trust in the system.
Order. Look, you're dealing with an amendment. You are now recounting something that is not in respect of the amendment. So I just encourage you to address the amendment rather than the history of a particular mayor, however grievous the case is.
Well, I'll go back to the point, Deputy President. The proposed amendment would remove all that angst, all that delay in flushing out those conflicts of interest. And that is just, I'm just using that exemplar because it's the latest example of what we've got, and we all know why we're here tonight is because of that. So I urge the House to support the amendment. Let's ban property developers from even being candidates on local government, because it's the right thing to do, and as was pointed out before by my honourable colleague Mr Shoebridge, the public expect it. This is what the public deserve, and I think they would be horrified to understand that we're still up here debating whether or not property developers can be candidates for local council or be on council.
Just before I call on the next speaker, it being 10 o'clock.
I do now move that we pass.
No, you won't. Minister.
I'm not going to move it.
Good, all right. I'm going to give it to the Honourable Walter Court.
I rise to make a very brief contribution. Many members have pointed out the Honourable John Graham, the Honourable Courtney Hewsauce, that I've actually spoken over the last 10 years about this matter, about banning property developers from standing in local government as the Shadow Special Minister of State and in various capacities, and this has been Labour Party policy for a long time. We believe that property developers should not be able to stand. I wasn't going to make a contribution until I actually heard the contribution from the Mr. David Shoebridge, and I accept his praise and his acknowledgement of the hard work of the late Dr. John Kay. But I do think that Mr. Shoebridge has very rose-coloured glasses when it comes to the contributions in this chamber of Mrs. Sylvia Hale and Miss Lee Rhiannon. And I'll leave my comments there.
The Honourable Adam Searle.
Mr Deputy President, I rise to make a contribution on this amendment, and I'm very pleased to do so. I've spoken on proposals like this in this chamber on a number of occasions, and along with others in my party, I did campaign for a party policy that would see the Labor Party not permit developers to seek public office as council candidates. And that was not always an easy road to hoe inside the New South Wales branch of the ALP, and did get me into some hot water from time to time. But, Mr Deputy President, it appears I'm no stranger to that. But to turn back to the amendment, and to take squarely the point raised by the Leader of the Government, this is not a proposition that members should feel would be exposed to attack in the High Court. In fact, it is the missing bookend of existing prohibitions on developer donations in the legislation. That provision, or those provisions, was squarely challenged by the then Lord Mayor of Newcastle, Jeff McCloy, in the McCloy versus New South Wales 2015 High Court decision. And Mr McCloy felt that his democratic right to donate to his own campaign had been infringed by the legislation.
Also a walk-in ATM for the Liberals.
I acknowledge that interjection, but the High Court said this: there is an implied freedom of political activity, but those freedoms can be burdened by legislation if the point of the burden is to actually maintain the integrity of the system of representative government, in this case in the council context. So, unlike in the United States, for example, these implied rights found by the High Court to exist are not a personal right that a citizen has, but it is a system right. It is a right that exists to protect the integrity of the electoral process and the system of elections, and either the representative democracy in councils or in Parliament. Now, that being the case, in the case of developers, it was accepted by the High Court that there was a live risk to the integrity of the process and to the integrity of important decisions made by elected bodies that could be undermined by developer donations. And so, to the extent that the legislation prevented those donations and inhibited those democratic rights, it was accepted as being both reasonable and proportionate and directed to addressing an evil in the system. So let's fast forward to this provision. This is the missing bit, because it may be that developers can't donate money to political campaigns, but they can still run for office. They can still hold office, apparently as the Mayor of Strathfield. And I won't go into that matter because it's been well canvassed, including in calls for papers. But the point is, there is a democratic deficit of people can bypass the legislative prohibition on making donations and actually get elected to council and make planning decisions such as what shape local environment plans should be, which of course frame all of the individual planning decisions made in a local government area. So this is a missing piece of the jigsaw that is both reasonable and necessary to complete this aspect of reform and protect the integrity of decision-making at local government level. It is not anti-democratic. It does inhibit some people's rights to run for election, but it doesn't do so because we don't like them or because people don't like them or because somehow they're deemed as being in some way undesirable. It is to protect the integrity of those elections and is to protect, importantly, the integrity of the decisions made by elected councils. So I give wholehearted support to this provision, but we can take comfort that provision, this counterpart provision in terms of the donations has already withstood attack in the High Court, and although you never can predict which way the High Court will go on any matter, given that this is actually directed to addressing the same evil, but at a loophole, if you like, that exists in the current legislation, I would be astounded if the High Court reached a different view on a provision like this to the one it reached unanimously in the McCloy case. So members should take heart from the McCloy case and should have no hesitation in embracing this proposition on the basis that it might be subject to legal challenge. I accept there are philosophical issues here of the kind raised by the Honourable Mark Latham, and I understand the principled view of the Liberal Party in allowing developers to run their councils and fill their coffers. But the point is, it has to be stamped out, Mr Deputy President. So let's vote for this and let's send it to the other place.
Yes, here, here.
Mr Chair, look, I'd like to thank all members for their contributions to this amendment. There's just a couple of points I'd wish to address to sort of respond to some of the contributions made.
Well, can I just make the observation? This is not a speech in reply.
I know.
You're entitled to speak, but
I'm just trying to put some context in what I'm saying. So first of all, the Leader of the Government suggested that the definition of property developer, which is incorporated in this amendment, being the definition that's found in the electoral in the Electoral Funding Act, is somehow very broad and would catch somebody who owns a coastal getaway property who did two development applications for it. Well, 3 and 7 years, I think, is the test, and then you'd be trapped, according to the Leader of the Government. Well, I'd urge the Leader of the Government to read the law before making those kind of contributions, because the definition that's incorporated is the definition that's found in the Electoral Funding Act, and he seems to have accidentally forgotten the first key part of that definition, and I'll just read it onto the record. Property developer, for the purposes of this division, and this is section 53. Property developer for the purpose of this division is A, an individual or corporation if 1, the individual or corporation carries on a business mainly concerned with the residential or commercial development of land with the ultimate purpose for the sale or lease of the land for profit.
That's a business.
And I stress there's multiple elements in that. The business must be mainly concerned with the residential or commercial development of land. And I hear a bunch of nattering around from the Libs. They may not like the law, but
I called Mr Shoebridge to order before for unnecessary interjection. I say to the Government Whip, Parliamentary Secretary Mr Taylor Martin, and to Mr Wearspan, all of you are interjecting. Next time you can call Mr Shoebridge.
so to make it easier, I'll break it down into the sub-clauses. The individual must carry on a business mainly concerned with the residential or commercial development of land. That's one part of the test. So the business has to be not about renting out properties, but it has to be concerned with the residential or commercial development of land. And if you're making incidental, so that's the first point. Not renting or leasing, but they're concerned with the residential or commercial development of land. And then it must also, in addition to that, have the ultimate purpose of the sale or lease of the land for profit. So it's not just leasing a house out. You have to be in the business of property development. And then in the course of that business, and I think the Leader of the Government, if they think they've got a different view, could probably make that contribution having read the bill, having read the Act, rather than by interjection. In the course of that business, A, one relevant planning application has been made by or on behalf of the individual or corporation, and a planning application is a rezoning application. As I said before, that's where the real money's made. Or B, 3 or more relevant planning applications made or by or on behalf of the individual or corporation within the preceding 7 years. So it's cumulative. You need to have a business. The business has to be mainly concerned with residential or commercial property development, and it has to be for the ultimate purpose of the sale or lease of the land for profit, and you have to have done multiple planning applications. It's cumulative. And the idea from the government that that's somehow a really broad definition, I think is a deliberate misreading of the definition of property developer. It's narrow on one view. It may well be too narrow, because there are people who engage in large-scale property development that probably could be excluded from that definition. But anyhow, that's the definition. It's narrow, it's focused, and the government's argument have no merit. Arguments have no merit. The idea as well that it's somehow it's going to breach the implied limitation on legislative action, which may trespass upon political communication in this country, also has no merit. I endorse the arguments put by the Honourable Adam Searle, but I'll just point out what the High Court actually found in the McCloy case, because that's the argument against this. It'll be somehow struck down as constitutionally invalid.
If you're going to mention the birthday case.
There was a joint judgment in the High Court, and they found that the laws that prohibited donations from property developers were not invalid because those capping provisions were, and I'll quote from the head note, aimed at the legitimate end of preventing corruption and undue influence, and reduce the risk of corruption and undue influence by preventing the payments of large sums of money through political donations. That was the legitimate end. And if the High Court was concerned about property developers donating to councils because of that creating undue influence, I don't think it's a big stretch to say they may have a concern about property developers actually being on council. You'd almost say that that's a far, far bigger risk. And then in order to determine whether or not the constitutional implied freedom of political communication is breached, and let's be clear, it's not an absolute freedom, it's a qualified freedom, and it's a limitation on what governments can do. It's not actually a right. It's a limitation on what governments can do to restrict communication. There's now a three-part test following the McCloy test, which extends. There used to be a two-part test in Lange, but anyhow, it's now a three-part test. And the three-pronged test is, does the law effectively burden the freedom in its terms, operation or effect? It arguably doesn't burden political communication, because it's not about political communication, it's about standing for office. But assume it does have some minor limitation, because you can't be both a property developer and a councillor. Are the purposes of the law and the means adopted to achieve that purpose legitimate, in the sense that they're compatible with the maintenance of a constitutionally prescribed system of representative government? Well, yes, it clearly is. 99.99999% of people can still run for council, and if someone who is a property developer wants to run for council, they can cease being a property developer. And thirdly, is the law reasonably appropriate and adopted to advance a legitimate objective? Well, we would argue it clearly is. It's interesting hearing the constitutional arguments being put by the leader of Pauline Hanson's One Nation party in this House. We don't necessarily we don't adopt those arguments. We don't think they're well founded. We believe it's not only legitimate and focused, but essential.
No, I've got them. Yeah, so don't worry about them.
All right, Mr. Shoebridge has moved that the question be amended by inserting after the heading Schedule 1 Amendment of the Local Government Act 1993 amendments appearing on sheet C 2021-076A with an additional amendment to the long title. The question is that the amendment of Mr. Shoebridge to the motion of the Honourable Don Harwin be agreed to. All those in favour, please say aye. Aye. Those to the contrary, no. Aye. I think the noes have it.
The ayes have it.
Division required. Ring the bell.
An extra 8 steps in will be shade back. That's what it's all about. That's right, no worries, Mr.
All okay.
someone's here. I don't know who it was.
Are you doing this bill though?
Yeah, it's finished.
Oh, is it?
After this division and a few procedural motions which will be adopted, it's finished.
So we'll go to adjourn.
No, we've got another bill to do after this.
Okay, all right.
Okay, so if you go and get your stuff quickly and come straight back down, that's all good.
Working my way through. Estimates will be fun.
Quite like to be having a nap about now. I'm tired.
Sure. Well, we progress slowed considerably.
Yeah, what happened? Why?
It just got procedurally complicated.
Right, okay. Yeah, well, I mean, there weren't divisions. Leave you in charge for 5 minutes.
Where's your
What happened?
It's a simple exercise.
You're down here to speak. Come on, speak. No. That's fair warning.
Oh, yeah.
That's right.
We've been down this part. We've been down this part. Yeah, this is the late one.
How we're through that.
Yes.
Yeah.
The others like, okay.
Order. Lock the doors. Mr David Shoebridge has moved that the question be amended by inserting after the heading Schedule 1, Amendment of Local Government Act 1993, amendments appearing on Sheet C 2021-076A with an additional amendment to the long title. All those in favour of the amendment of Mr Shoebridge now please stand.
Glad you provided me with the guidance.
And I appoint the opposition whip and the opposition deputy whip, sorry, as tellers for the ayes.
So do we just need to report 1, 2 and delete 3? But it works as like a blanket because it's multi-purpose.
Very good. They're wildly popular. You're making me hungry with all
Every time you take a step, you're killing something. You want us to have this debate?
No, as I said, whatever you come up with, I'm sure we've got it reasonable.
Thanks. If the ayes could now take their seats and the noes please stand. Oh, have you? And I appoint the Government Whip and the Deputy Government Whip as tellers for the noes.
over the course of a couple of hours.
You haven't been doing too good so far. There being 23 ayes and 18 noes, the question is resolved in the affirmative. Unlock the doors. The question is now is that the motion of the Honourable Don Harwin as amended be agreed to. All those in favour, please say aye. Those the question, no. I think the ayes have it. The ayes have it.
What are you talking about?
Have it. The question now is that the Electoral Legislation Amendment Local Government Elections Bill 2021 and the Local Government Amendment Elections Bill 2021 be agreed to. All those in favour, please say aye. Aye. Those the contrary, no. I think the ayes have it. The ayes have it. Minister.
Mr. Deputy President, I move that you do now leave the chair and report to the House that the committee has considered the Electoral Legislation Amendment Local Government Elections Bill and, according to the instruction given by the House, has divided the bill into two bills, the Electoral Legislation Amendment Local Government Elections Bill and the Local Government Amendment Elections Bill 2021. 2, that the Electoral Legislation Amendment Local Government Elections Bill 2021 be reported without amendment. 3, that the Local Government Amendment Elections Bill 2021 be reported without an amendment, which is the form that given that. She promises me.
Yeah, it is right. I think I'm going to put it this way. The question is the motion of the minister. All those in favour, please say aye. Aye. Those the contrary, no. I think the ayes have it. The ayes have it.
It did seem counterintuitive to me.
You are going to report that, are you?
I am.
Excellent.
Mr President, the committee reports that it has considered the Electoral Legislation Amendment Local Government Elections Bill 2021, and according to the instruction given by the House, has divided the bill into two bills, the Electoral Legislation Amendment Local Government Elections Bill 2021 and the Local Government Amendment Elections Bill 2021. The committee reports the Electoral Legislation Amendment Local Government Elections Bill 2021 without amendment. And the Local Government Amendment Elections Bill 2021 without...
Yeah, no worries.
Without an amendment. Without an amendment.
Yeah, we did.
I'll leave that to you.
We amended the instruction, not the bill. So once we apparently once we amended the instruction, everything was fixed. So,
Sorry?
she promises me, I trust her. Oh, I see. We worked with her for a very long time. A lot of time for her.
The amendment becomes...
The committee reports as outlined by the Deputy President.
Yes.
Minister.
Right.
Yes. Mr President, I move that the report on the Local Government Amendment Elections Bill be adopted. Did I leave one out? Yes. Mr President, I move that the report on the Electoral Legislation Amendment Local Government Elections Bill 2021 be adopted.
The question is the motion of the minister. All those in favour say aye.
Aye.
Against say no. I think the ayes have it. The ayes have it.
Mr President, I move that the report on the Local Government Amendment Elections Bill 2021 be adopted.
The question is the motion of the minister. All those in favour say aye. Aye. Against say no. I think the ayes have it. The ayes have it.
Mr President, I move that the Electoral Legislation Amendment Local Government Elections Bill 2021 be now read a third time. Yeah, there will be.
Come to that.
I'll do the same motion straight after this one.
I have a certificate from the Chair of Committees that the bill is in accordance with the bill as reported from the Committee of the Whole. The question is that this bill now be read a third time. All those in favour say aye.
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 Against say no. I think the ayes have it. The ayes have it.
Electoral Legislation Amendment Local Government Elections Bill 2021, third reading.
Mr President, I also move that the Local Government Amendment Elections Bill 2021 be now read a third time.
President.
The Honourable John Graham.
I want to speak briefly in the third read on this bill, given the process which we've just undergone. So the bills have now been split. They'll both travel down to the Assembly. I want to thank the Leader of the Government firstly for the tenor of the discussion that's occurred. These are issues that there are strong feelings in the House, but I thank the Leader of the Government for the way he's conducted this debate. He was very persuasive about some of the issues he presented, including the provisions of this bill that is now before the Chamber in relation to the local government amendment. This bill, if carried by the other place, will put in place COVID measures that are important for nursing homes, for aged care institutions. They've been requested by the Electoral Commissioner. It also contains measures that this House has asked that will restrict property developers from running. Those things travel together now to the Legislative Assembly, and I re-put my invitation to the government to change its position in that place.
Is there any other member seeking the call? Mr Shoebridge.
Mr President, I just want to reiterate our concerns that the government may not pass the second bill, the Local Government Amendment Bill. The Greens are committed to seeing the powers being given to the Electoral Commissioner to ensure that the elections can be COVID safe. Those powers need to be given well in advance to the local council election. It cannot be delayed in the other house this week. For the reasons, indeed, this minister gave in the second reading speech in adopting it, pointed out how important it was to have these powers, particularly to protect voters in vulnerable situations such as nursing homes and indeed in hospitals and other vulnerable locations. And the thought that those protections may not become law because the Liberal and National parties are so committed to having property developers on councils, I think would be an appalling outcome. So we urge the government to move both of these bills swiftly through the other house.
We'll cross that bridge when we come to it.
There's no other members seeking the call. I have a certificate from the Chair of Committees that the bill is in accordance with the bill as reported from Committee of the Whole. The question is that the bill be now read a third time. All those in favour say aye. Aye. Against say no. I think the ayes have it. The ayes have it.
Local Government Amendment Elections Bill 2021, third reading.
Okay.